The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States of this honorable court. The case on the calendar is Cecilia Chung versus Gabby Rivera, Chair of the City of Willow School Board.
All right, counsel, we ready to proceed?
Yes, Your Honor.
Okay, and who's representing the petitioner?
Alexandria Harris, along with Molly Hatch.
And counsel for the respondent?
Yes, Your Honor. Chelsea Ogan, and my co-counsel, Shelby Velasquez.
And I was going to let Justice Baldwin be the chief, but I mean, I'll let her kick it off. I wanted to break the awkward silence that we were having. Justice Baldwin, whenever you're ready.
Or actually, you were doing just fine. I will make an admission before we get started. My internet seems to be a little choppy this morning. So please do not have me be the chief because I don't want to mess up anything. Please.
Just Tiarina, if it's okay with you, I'll continue as well.
Of course.
And so, counsel for the petitioner, are you saving any amount of time at this point for rebuttal?
Yes, Your Honor. 2 minutes for rebuttal, please.
Okay, so whenever y'all are ready to proceed, you may begin.
May it please the court. My name is Alexandria Harris, and along with Molly Hatch, I represent Ms. Cecilia Chung, the petitioner in this case. This case highlights the fundamental truth that no matter one's religious beliefs, she has a valued place within her political community. We are here today because Ms. Cecilia Chung was denied that valued place within her local school board community when Policy 310 was enacted. This court should reverse the judgment and remand the case because the Court of Appeals failed to observe that fundamental truth. More specifically, the Court of Appeals erroneously affirmed for 2 reasons. First, the Willow School Board's invocation policy was not correctly identified as a legislative prayer. And second, the school board chair acted under color of state law in blocking Ms. Chung. The standard of review is de novo. I will show why the appellate court erred in viewing the invocation as legislative prayer, and Ms. Hatch will show why the appellate court erred in failing to see that Ms. Rivera acted under color of state law. The Establishment Clause under the First Amendment ensures that the government in no way make any acts to make beliefs.
Counselor, is there a circuit split on this?
I'm sorry, Your Honor?
Is there a circuit split on this? Have other circuits already addressed this issue?
Yes, Your Honor. This issue regarding school boards and legislative prayer has been addressed by the 9th and the 5th Circuit. They are virtually split on whether or not the legislative prayer does fall within that exception.
Shouldn't we just wait till the rest of the circuits decide then? Like, should we really be here deciding this right now?
Yes, Your Honor, we should be here today, specifically because we should not wait for others to move forward on the issue. Ms. Chung is being denied her First Amendment right under the Establishment Clause. And for that reason, we must address this today.
So what, counsel, what Establishment Clause test would you have us use in this instance?
Your Honor, the courts have considered whether in evaluating whether an invocation violates the Establishment Clause, whether it is a religious or non-religious practice, whether it invites a school prayer case or a legislative prayer case, and whether it abides by the Lemon 3-prong test. Today, we will use all three.
So when I go to yoga and I meditate at the beginning and at the end of class, are you saying that that I'm praying?
Not necessarily, Your Honor. To my first point, meditation has not transformed to hold a universally secular meaning. Although it is accessed today through meditation apps, and as you mentioned, Justice Sandel, in a yoga class, it still does not hold a secular meaning. If I may direct your attention to Black's Law Dictionary definition of secular, it states that secular is not spiritual, not ecclesiastical, and relating to affairs of the present world. The key word here that we will focus on is not spiritual. Whether you are in a yoga class or accessing that through an app, meditation is still a spiritual practice, and it has not transformed to hold a secular meaning like the cross. This court held in American Legion that the cross at the World War I memorial on public land was constitutional. Although heavily associated with Christianity, the cross did not violate the Establishment Clause because in many contexts, the symbol has taken on a secular meaning.
Now, let me ask that, is that, and let me be clear, I mean, so meditation is older than the cross.
We do not dispute that fact, Your Honor.
Okay, but you're still saying it hasn't taken on a secular meaning.
That is correct. Yes, Your Honor.
Okay, continue, counsel.
Unlike the cross, meditation remains highly connected to the Buddhist faith. To say that it holds no religious meaning is dishonest to both the Constitution and the Buddhist faith itself. Here, the practice of meditation at the Willow School Board meetings remains connected to the Buddhist faith and is highly spiritual in nature, not just because it is known to be associated with Buddhism, but because it is primarily led by Buddhist monks who enlist the recitation of Buddhist mantras. This court held in Town of Greece that having a priest lead a legislative prayer does not necessarily make it unconstitutional, and that is not our point of contention here today. The issue here today is that meditation is a medium that does not lend itself to all faiths. Here, Ms. Cecilia Chung is contesting this platform because as a Christian, she believes that it conflicts with her faith and is thus unable to participate in the meditation practice.
Would we be here today if the invocation was led by a Christian practitioner?
Yes, Your Honor, we would. Because meditation is a medium that is unlike prayer. Meditation is only adopted by certain religions and is not adopted by all. So if it was adopted and universal, because even atheists pray, even people of the Church of Scientology pray. So that is a more universal platform that lends itself to not blocking anyone's First Amendment right under the Establishment Clause. Since meditation holds a religious meaning, in order to decide whether the invocation is constitutional under the Establishment Clause, I would like us to turn to the consideration of whether it is a school prayer case or a legislative prayer case. To my second point, although a school board is similar to a legislative body, the board revolves around public school education. The Constitution should treat school board meetings no differently than from a high school graduation. This court held in Lee v. Wiseman that legislative prayer was unconstitutional because school authorities maintain close supervision over the conduct of the students and the substance of the ceremony. Here, school officials are doing the same at the school board meeting.
And it's my understanding, Ms. Harris, that students were obligated to attend these meetings. Is that correct?
That is correct, Your Honor. And that is exactly why we're here today. The student attendance in no way was voluntary. Students did attend for various reasons, including disciplinary hearings and student performances and student awards. However, if a student that was required to be there did not attend, they were then subject to further disciplinary action by the board.
Counselor, wasn't one of the main decisions though because of how impressionable students are? I mean, these are adults at the school board meeting, like shouldn't they be able to just be okay with what's happening and everything?
No, Your Honor, it was not only adults at the school board meeting. Because there were so many students present, that is the issue here. Not only is it just, this court has held that students present at a school board meeting does not automatically make it a school prayer case. However, the issue here is that students were required to attend. It was not an option for students to be there. They were required to be there. Unlike in American Humanist, where students' attendance was wholly voluntary. As mentioned earlier, this is a case of first impression. The circuits are split on whether invocations at a school board meeting are constitutional, specifically because students are present. Here, we suggest that the court follow the Ninth Circuit's lead in Freedom from Religion, which held that the prayers were unconstitutional, specifically because students sat on the board.
Are you asking us to decide today on a fact-specific, make a fact-specific determination, or are you asking us to create a bright line rule between school board meetings and other sorts of bodies that meet to engage in policy discussions and vote on policy agendas?
The former, Your Honor. We are not asking the court to make a bright line rule here today. However, in looking at the totality of the circumstances where students are present and required to attend, we ask that this court hold the legislative prayer exception should not apply. As to a subpoint, in order for a school prayer invocation to be constitutional, the policy must pass the Lemon test. So if we say that the legislative prayer exception here does not apply and it falls under school prayer, it must pass this three-pronged test.
Counselor, what do you think is respondents' strongest case in their favor?
Your Honor, I believe that their strongest case would be following in the footsteps of the legislative prayer. However, because students are required here, we ask the court to not follow in those footsteps. Although this court has expressed concern with the Lemon test in American Legion, we do remind you that the concern was specifically with the original purpose and the passage of time. This concern should not inhibit our application here today. I'd like to draw your attention to page 5 of the record, which states that the intended purpose is to foster productivity. While the Lemon test has 3 prongs, a secular purpose, a principal or primary effect that neither inhibits nor enhances religion, that is our point of contention. The fact that this is meditation inhibits other religions from participating who do not practice meditation, and it advances those that do.
It's clear that it's meant to enhance religion, right? I mean, they allow anyone from this particular monastery to be on the invocation list, as opposed to others who have to apply to be on this list to participate in the invocation process. Isn't that correct?
That is correct, Your Honor. I see that I'm out of time. May I quickly respond to your question and briefly conclude?
Please.
That is correct, that it seems as if this is being favored towards Buddhist monks. And if it is, that is not the issue here though. If the Buddhist monks are leading the meditation, that is okay. Our point of tension is the fact that meditation cannot be accessible by people of every religion, such as Ms. Chung here. For these reasons, the petitioner respectfully requests that this court reverse the judgment of the Court of Appeals and remand the case. Thank you.
Thank you, counsel. Ms. Hatch?
Thank you, Your Honors, and may it please the court. My name is Molly Hatch, and I, along with Alexandria Harris, represent Ms. Cecilia Chung, the petitioner in this case. This court should reverse the appellate court decision because the respondent did violate Ms. Chung's right to free expression and acted under color of state law when she did so, for two reasons. The first reason is that the Court of Appeals correctly concluded that the respondent's LinkedIn page is a government-created forum. The second reason is that the Court of Appeals failed to see that the respondent acted under color of state law in her official government capacity when she blocked Ms. Chung. To prevail in her claim, Ms. Chung must show two things. The first is that she was deprived of her First Amendment right to express herself in a public forum. The second is that the party that violated her right acted under color of state law, according to 42 USC section 1983. She has fulfilled both those elements.
This case is completely on point with the Trump Twitter case, correct?
Your Honor, that is correct. Just as President Trump's Twitter page was a government forum, so is the respondent's LinkedIn page. To my first point, the respondent's LinkedIn page is a government forum, as the Court of Appeals correctly concluded. And while the Court of Appeals concluded that the page was a non-public government forum, I will argue that it is actually a traditional one. This court, in International Society for Krishna Consciousness, said that a traditional public forum is a place that has a principal purpose, which is the free exchange of ideas. What is a social media page, if not a place devoted to the exchange of ideas? By that analysis, the respondent's page is a traditional forum. If not, in International Society, this court also said that the decision to create a public forum can be made by intentionally opening a non-traditional forum for public discourse. The respondent—
Counselor, isn't it true that she uses this for other matters, such as the fact that she's a co-owner of an auto shop? So there are other things not necessarily related with the school board.
Yes, Your Honor, that is correct. However, just as other government officials, such as President Trump, post about some personal things on their pages, such as, say, their children or other aspects of their personal life, that does not mean that it's not a public forum. Also, the respondent handed out cards with a link to her page on them and accepted over 1,000 members of the community to connect with her page.
Counselor, what would you rather her do though? Have two separate LinkedIn accounts? I just don't really see how this would be practical.
Your Honor, if the respondent wished to keep her personal life and her other matters out of the public forum that she created, she was fully free to do so.
So I'm taken aback, Ms. Hatch, because it seems to me by making the statement that you believe it's a traditional public forum, you're opening up a bag of worms. What's the difference then between a traditional public forum and a designated public forum? Does our analysis change?
Your Honor, our analysis does not change because as this court decided in Pleasant Grove, the blocking of constituents' viewpoints is highly scrutinized in the same manner in both traditional fora and designated fora.
So why make the giant leap in saying that it's a traditional forum as opposed to a designated forum? I'm curious because to me, Justice Baldwin's question makes a whole lot of sense when you're making the point that it's traditional forum as opposed to if it's a designated forum. I think you have a little bit more leeway on your side. I'm just trying to figure out why you're making that intentional differentiation.
Your Honor, I argue that it is a traditional forum because in today's society, amidst ever advancing technology, we must be careful in not allowing people to express their viewpoints on pages created by government officials. And I would argue that a social media page is a traditional forum because of that aspect of our society. But if not a traditional forum, the respondent's LinkedIn page is at least a designated one. The Second Circuit Court in Knight versus Trump reasoned that a social media is entitled to the same First Amendment protections as other forms of media amidst ever advancing technology. By conveying school board matters to her connections through her LinkedIn page and holding discussions with her connections about school board matters on the page, the respondent at least created a designated public forum, just as President Trump did. Furthermore, the Fourth Circuit Court held in Davison that a county board chair's Facebook page was a public forum. The only thing that is different between the Facebook page and the LinkedIn page is LinkedIn's Connect feature. However, the respondent virtually disregarded that feature when she accepted over 1,000 connections from members of her community. There is no way that the respondent personally knew the 1,000 plus connections that she made at school board meetings. Thus, when the respondent accepted all of those connections, she opened up her page to the public as a public forum. This was not a privacy issue for the respondent, but instead an attempt by the respondent to prevent Ms. Chung from asserting her place in her city's political community.
You have less than 5 minutes remaining, just FYI.
Thank you, Your Honor. This brings me to my second point. The Court of Appeals failed to see that the respondent acted under color of state law when she blocked Ms. Chung from her LinkedIn page. The nexus test should be used to determine whether the respondent acted under color of state law. In Davison, the Fourth Circuit said that a defendant's private actions bear a sufficiently close nexus with the state to satisfy 42 USC section 1983 when the defendant's challenged actions are linked to events which arose out of her official status. The challenged action here is the respondent's blocking of Ms. Chung from her LinkedIn page. The reason that the respondent did so is that Ms. Chung did not agree with one of the respondent's school board policies and attempted to voice her opinion in a public forum created by the school board chair. Thus, the respondent—
Counselor, is blocking someone on social media an exercise of traditional state power? How can it be if social media is so new?
Your Honor, I would not say that it's a traditional exercise of state power. However, according to the nexus test, if there is a sufficient nexus between the actions and the official status, then 42 USC section 1983 is satisfied.
Well, by blocking Ms. Chung, Ms. Rivera also protected the clearly personal discussion she has using the account. Doesn't that make the nexus tenuous?
No, Your Honor, it does not. Ms. Chung's comments were not at all related to the respondent's personal matters.
Let me ask this question. Let's go down the slope a bit. What if all she did was just delete Ms. Chung's comments, like she did in this case? Would that be state action as well?
Yes, Your Honor, it would be, because that would still be viewpoint discrimination, and it would still be the respondent suppressing Ms. Chung's views.
So you're saying that an elected official or a policymaking official is working under the color of law if they use a social media platform in any way whatsoever to forward their work as that public official, and then make any adverse action related to viewpoint. So if I was on Ms. Rivera's LinkedIn page and I quoted something about how schools shouldn't put fluoride in their water, and she deleted that comment, you would say that was state action?
Yes, Your Honor, I would, because you are entitled to your viewpoint as Ms. Chung was when she left comments on the respondent's LinkedIn page. And no matter your viewpoint, You should be able to voice your view in a public forum that was created by a government official for the purpose of holding discourse with members of the community related to the capacity that the government official holds.
Counselor, you just said no matter your viewpoint. That's kind of broad. That's not what you mean, is it?
Your Honor, that is what I mean.
Are there certain languages or categories of speech that would not still be allowed for him to post on the LinkedIn page?
Your Honor, unfortunately, in today's society and the way that social media is, government officials, when they open up social media to hold discourse with the public about their official positions, they might be subject to some unwanted comments from the public. However, they are not entitled to suppress anyone's viewpoint, no matter what that viewpoint is.
What about if it was a threat that he made or some type of like super vulgar image?
Your Honor, I see that I am running out of time. May I answer your?
I'm going to object to that question by Justice Tiarina, by the way. I'm just messing around. Go ahead.
I see that I'm running out of time. May I address your question and conclude?
Of course.
Thank you, Your Honor. Threats are different as someone's life is at stake. So I would say that there should be action taken when threats are left on anyone's social media page, government official or not. However, that was not the case here today. The case here today is that there was apparent viewpoint discrimination in a public forum. For these reasons, we ask this court to reverse the appellate court's decision and allow Ms. Chung to assert both her freedom from religion and her valued place in the political discourse of her city. Thank you.
Thank you, counsel. Counsel for the respondent, Ms. Rivera.
Thank you, Mr. Chief Justice, Your Honors, and may it please the court. My name is Chelsea Ogan, and I, along with my co-counsel, Shelby Velasquez, represent the respondent, Ms. Gabby Rivera, Chair of the City of Willow School Board in this matter. I will address the issue of the Establishment Clause. The issue in this case are a question of law, and therefore the standard of review is de novo. The court should affirm the judgment of the 15th Circuit Court of Appeals in granting summary judgment for the respondent and hold that invocations do not violate the Establishment Clause for 3 reasons. First, meditation is neither a religious nor non-religious practice. Second, the invocations given at the City of Willow School Board meetings are legislative prayer rather than school prayer. And third, the invocations satisfy the Marsh legislative prayer exception test, and therefore there is not a violation of the Establishment Clause. First, we believe that the Establishment Clause is not an issue in this case because meditation is neither a religious nor non-religious practice. As Judge Sandhill, or Chief Justice Sandhill mentioned, the meditation is led by Buddhists and it is a fundamentally Buddhist practice. However, this court has ruled that practices or symbols that have been historically attributed to a certain religion can and do evolve over time to have secular meanings. For example, in American Legion, the American Humanist Association, the court held that traditional Christian crosses have evolved over time to have a message that is almost entirely secular.
Don't you take that historical evolution nation to nation? Like in India, if you meditated, I could understand that you've been doing it for 5,000 years, so it's taken on a purpose outside of its traditional religious base. And in America, we're a Christian country, and we use the cross in a lot of different ways. But history in and of itself doesn't make it okay. It has to be American history that makes it okay, correct?
Yes, Your Honor. First, I would disagree that America is a Christian country. I do not believe that that is an appropriate characterization of the religion in this country. However, as the record cites on page 5, the meditation used breathing exercises It invoked universal themes of peace and productivity to promote the mental and emotional well-being of legislators that have to deal with the fractious business of governing. I do believe that these themes of productivity, peace, and mental and emotional well-being do reflect the heritage and tradition of this country. Therefore, meditation
why were only one group of persons automatically included on the list, whereas all other persons who wanted to participate had to apply?
Certainly, Your Honor. The respondent believes, and as your question states, that we believe that the meditation states that it should be considered secular despite the Buddhist monks giving the invocation for two reasons. First, the Buddhist monks were not the only individuals to actually give the invocation. Ms. Rivera also gave the invocation. Additionally, as the record cites on page 14, Board Policy 310 allows any volunteer member of the community who is certified in meditation to give the invocation. I would also like to point out a source of confusion. The record cites on page 5 that Ms. Rivera practices meditation herself, but nowhere in the record does it state that she follows the Buddhist faith. Ms. Rivera simply believes that Ms. Johnson, the monk who often leads the invocations, as well as the monks who are put on the list, support the board's mission of ensuring mental and emotional health of the community, rather than advocating that the monks in the Buddhist faith should be used as a specific opportunity for meditation. This brings me to my second point on the secular issue. While the respondent acknowledges that Buddhist monks often lead the meditation practice, as the record states on page 5, the meditation uses breathing exercises along with a mantra to express universal secular themes, such as mindfulness, productivity, and less conflict. We believe that it would be erroneous to claim these themes should be attributed solely to the Buddhist faith rather than recognize their secular significance. For my next point, we are stating that the invocations fall under the legislative prayer exception to the Establishment Clause. As the petitioners correctly stated, this court has not specifically addressed whether invocations given at the beginning of school board meetings constitute legislative prayer or school prayer. However, several circuit courts have. In American Humanist Association v. McCarty, the Fifth Circuit determined that invocations given before school board meetings did constitute legislative prayer. They reasoned that because the school board is tasked with overseeing district public schools, adopting budgets, conducting elections, and other undeniably legislative tasks, the school board is therefore more like a legislature than a school classroom or event. And the
Counsel, is that a fact-intensive inquiry? I mean, do we have to look at the specific facts of every school board meeting to come to that determination? Or are you saying as a bright line rule that all school board meetings are legislative meetings?
Your Honor, we believe that this is a fact-specific inquiry.
And so in this case, counsel for the petitioner stated that high school students had to be present because if they weren't present for some issues, they could be reprimanded. Is that true about your school district's policy?
This is also a point of confusion that I would like to clear up, Your Honor. It is true that in some limited circumstances, students are required to be at the school board meetings. However, there is no policy that states they have to be there for the invocation, nor do they have to be there for or participate in the invocation. There is an extra credit opportunity, as the record cites on page 16, that says students must attend an entire legislative meeting in order to receive extra credit for their classes. The respondent does recognize that extra credit can be the difference between a passing grade or a failing grade, and therefore it shouldn't be to a student's detriment not to be able to attend. However, as page 16 states, the school board meeting is not the only legislative meeting they are allowed to attend. They can attend city council meetings or state representative meetings as well. Therefore, we would disagree that students are required to be at the school board meeting during the invocation and participate in it, which is in fact what the petitioner's son did in this case. He simply left. Conversely, in the Freedom from Religion Foundation v. Chino Valley, the Ninth Circuit, as the petitioner quoted, did state that invocations given during school board meetings constituted school prayer because there was a student representative on the board that was required to be there at every meeting. Furthermore, the board in Chino Valley specifically and consistently invoked the name of God throughout the entirety of the meeting, and they explicitly linked the work of the board, the teachers, and the school community to Christianity rather than simply giving prayer as an opening ceremonial tradition.
Council, can we look at page 15 of the record? Student highlight and discipline takes place right after the invocation. So you're asking these students to guess when to attend for their own highlights and discipline, as opposed to conceding that this is school prayer?
Your Honor, because it does start at 7:10, we do believe that students have a reasonable expectation of when they can return to the schoolroom.
So what my question, I guess, more specifically, without letting you wiggle out of it, is what if you're off task? What if the invocation doesn't take place till 7:12 and my son is there at 7:10 because he was told by you to be there and now has to, I don't know what the correct term is, but has to engage in the meditative process because it has been made part of the policy of the school board? Are you not then subjecting my son to your meditative process?
Your Honor, we believe that your son would still be able to leave the court or to leave the school board auditorium as soon as the invocation started. However, let's say that this court today does find it school prayer. We still contend that the invocation in the City of Willow School Board will pass the legislative prayer, or will pass the lemon test that the petitioners brought up. While this court has stated that the lemon test is not good law when it comes to legislative prayer exceptions, it is still the appropriate framework to analyze whether school prayer violates the Establishment Clause. Even if this court finds it school prayer, it still does not amount to a violation of the Establishment Clause because it passes all three prongs of the lemon test. First, as the record states on page 5, the purpose of the invocation is to promote productivity, lack of conflict, and mental and emotional health, all of which serve a secular purpose. Second, the principal effect of the meditation is to suggest that attendees and legislators can benefit from the practice of mindfulness during the fractious business of governing. And third, the invocation is limited to the opening ceremonial portion of the meeting, and nowhere in the record does it state that students are required to pretend or participate. And even as the record states on page 5, the petitioner's own son was free to come and go during the middle of the invocation and choose not to participate. Furthermore,
why does this case matter? Why does it matter for future cases coming before us?
This case matters for future cases coming before us for one main, I'm sorry, Your Honor, I see that I'm briefly running out of time. May I finish your question and then briefly conclude?
Of course.
This case is about the First Amendment. And what is important is that the First Amendment is not a majority rule. Ms. Cecilia Chung in this case stated that her issue was that students were being dragged away from their Christian faith. However, this court has said that it is impossible for an invocation to be completely inclusive of everybody's beliefs. Therefore, the universal themes that were expressed during this meditation should be viewed as a tolerable acknowledgement of beliefs widely held rather than steps towards the establishment of a state church. And for those reasons, we ask that you affirm the judgment of the 15th Circuit Court of Appeals. Thank you.
Thank you, counsel. Ms. Velasquez?
Thank you, Chief Justice, your honors, and may it please the court. As my co-counsel stated, my name is Shelby Velasquez. I represent Ms. Rivera, and I will be addressing the second issue, whether blocking a constituent on a social media platform infringes on that constituent's right to free expression under the First Amendment of the Constitution. In my time before the court, I will show that the respondent, Ms. Rivera, did not violate the First Amendment when she blocked the petitioner, Ms. Chung, on social media. Therefore, this court should affirm the decision of the 15th Circuit Court and hold that a government official's personal choice to block a constituent from a personal social media account does not violate the right to freedom of expression for two reasons. First, Ms. Rivera did not deprive her of a constitutional right because Ms. Rivera's LinkedIn page is not a designated government forum. And second, because Ms. Rivera's actions were that of a private individual regulating a private space, she was not acting in a manner with a close enough connection to be considered acting under the color of state law.
Ms. Velasquez, going to your first point on the second issue, it was not designated a public forum. You're asking us to ignore our precedent in the Trump matter?
Your Honor, there is a key. Yes, I am, because there is a key distinction between the Trump decision. The circuit court held that his transformed into a public account when he encompassed the role, and he himself and his government officials admitted that the account was now his public account for the sole purpose of communicating with his constituents, and that these tweets were now in the record of the president, and therefore they became public records. And that is a key distinction.
Agree, Counselor, that Ms. Rivera is a government official. I mean, just like judges, no matter what happens, whether I have this robe on or not, I am still a judge. I am responsible for every communication I make under that position, whether I am on the bench or not. Would it not be the same for Ms. Rivera in this matter?
Your Honor, if you yourself had a private business and created a LinkedIn for the purpose of promoting that business separate from your title as a judge, it should not affect your ability to control who has access and who can comment on your posts on LinkedIn. The question of whether the social media account is a de novo, and although this court has found that a traditional forum hallmarks are that it is open for assembly and debate, either by designation or longstanding custom, Ms. Rivera has not done so in this case. Instead, she created it for the purpose of her private business and has maintained control over who has access and the ability to interact. As the record shows on page 6, LinkedIn is a social networking site focused on professional networking. Users may only comment and interact once they have a connection. This is a key distinction from President Trump and Randall in Davison versus Randall, who used public social media accounts that were open to anybody and were for the sole purpose of promoting their official capacity.
So, Ms. Velasquez, your distinction here is that LinkedIn is, you're telling this court that LinkedIn isn't available to everybody?
LinkedIn is available to everybody.
So what's the distinction? I mean, I understand that Facebook and Insta and Twitter, I mean, are easier and they're cooler and they're more hip. But the issue here is not what is hip and what isn't. The issue is what your client did to the forum. And I think that's the real issue here is, and what we're avoiding is any forum can become a designated public forum depending on the way it's used. And you're not, I don't think at any point here you're arguing that she didn't block Ms. Chung because of her viewpoint, are you?
No, we do not contest that.
I just wanted that concession. But then the issue becomes, if I turn this courtroom into an open vessel for everyone to come and share their remarks, even though the courtroom isn't a traditional place for us to exchange these ideas, it has now become a place for us to exchange ideas, correct?
You are correct, Your Honor, but Ms. Rivera has not done so. She has maintained the restriction to limit who has access to her LinkedIn and who can interact with her post.
Counsel, you would agree she's gained the connections that she has as a result of being a public official, correct? So why would that not be relevant?
Ms. Rivera connects with any resident, and although she does pass out cards before and after, we do not believe that this is for the purpose of her official role. Nowhere has she stated, connect with me on LinkedIn, voice your concerns, and I will address them, like Randall did and Davison v. Randall. Instead, she has merely connected with them to promote her business, and that is the primary purpose of her role on her social media account.
I mean, I think we're sort of light stepping over this, but I mean, you would agree with me that actions speak louder than words, correct?
Yes, Your Honor.
And the record reflects that Miss Rivera engages in policy discussions on her LinkedIn page with her constituents, correct?
Your Honor is correct about that fact. However, that characterization is incorrect. Although she responds to matters of the board topic, she does so in a capacity that any individual could do. She posts links that are on the public website separate from her LinkedIn. And when she responds, as you will see on page 19 and 23, she responds about matters that her as a private individual and parent of a child within the school district would know. For example, on page 23, when asked about whether certain students were recognized and if those parents were instructed, she said, yes, my son was recognized and the school board sent me myself a letter. That is something she became aware of separate from her position on the board. And therefore, we believe that that is why this is her LinkedIn is still for the main purpose of her business page. As you will see on page 20, 21, and 22, she has used her page to hire employees for her jewelry store. She has used her page to promote services of her business, and she has used it to promote the foundation of her business. And therefore, she did not transform this into a public account. And therefore, this court should hold that Ms. Chung was not protected from viewpoint discrimination because viewpoint discrimination is not protected from does not extend to private citizen speech. Thus, she was not deprived of a constitutional right. For my second point, Ms. Rivera's actions were that of a private citizen, and therefore they do not constitute a close enough nexus to be considered the actions under color of state law. The petitioner was correct in saying that Section 1983 requires a close enough nexus to be considered the authority of state law. This issue of whether a public official acting on a social media account to the color of state law is one of first impression. The lower courts have determined that we must examine the totality of the circumstances to determine if the action at issue bore a sufficiently close enough connection. A necessary fact-bound inquiry is required when a defendant's status is at question. Yes, Your Honor.
Do you condone her actions? Do you think it's right that she's doing this, that she's gaining this extra business, that she's speaking as a member of the school board? Isn't it? She probably shouldn't be doing those things, right?
While she may or may not have done it, she has ultimately done it to promote her business. And although she may have capitalized off of it, ultimately she's connecting with people that are in her community that she could have connected regardless of her position on the board. Had she gone to the board meetings and was never assigned the title, and she was just interacting as a person of the community, she could have still handed out these cards, inviting them to link with her. She didn't have to do this just because of her role. And therefore, there is not a close enough connection because she did not behave in any way that an individual, a private citizen, could have done. And therefore, she has not esteemed her account to the privilege and duties of her public capacity as seen in Randall and in Trump. Trump and Randall closed their account and their esteem and the privilege of their duties when they specifically used their accounts to promote their policies and to describe and defend them, and to release publications on both pages saying that these are the official statements and that anyone could interact with them. And that is the key distinction here. She has not invited anyone to interact with her for the sole purpose of her official title. And she has not esteemed her social media account to that of her public capacity, regardless of it being private or public. Randall did so when she incorporated, and Trump did so when they incorporated the official title to their page. However, Ms. Rivera still retains her private title. And that is a key distinction because President Trump used to have his only private title, but then added his public title, his only private title, but then added his public title as well. Ms. Rivera has still retained her private title and the main purpose and interaction of doing so.
Ms. Velasquez, your entire argument is premised on the fact that we don't find it to be a public forum. Once we find this to be a public forum, if she excludes somebody, isn't she exercising state power?
Your Honor, we do not believe so. Even if this is considered a public forum, we still believe that she has not committed a First Amendment violation because there is not a close enough nexus. Whether the account was private or not.
You've conceded that you blocked her solely because of her point of view.
Yes, Your Honor, but she has to have a close enough nexus for it to still constitute a violation. It is a two-pronged test. And therefore, because she has not esteemed it, whether it is public or a private forum, she has not esteemed it to the level of her official capacity because she has not included her public contact information.
Ms. Velasquez, that's to the point that I'm trying to make. Are you telling me that Ms. Rivera gets to make that decision and not this court?
Your Honor, I see that I am running out of time. May I answer your question and briefly conclude?
Yes, ma'am.
Your Honor, you are correct. You have the ultimate decision to decide if it is a public or a non-public, or if there's a close enough nexus. However, she has not created a close enough nexus regardless of if it is private or public because she has not esteemed it, because she has not said that these are her public records and she has not promoted it in that capacity, and therefore she has not included her public official role in this personal account, whether it's public or a private forum. And therefore, we believe that the 15th Circuit Court opinion should be upheld by this court. Thank you.
Thank you, counsel. And now we have a rebuttal by the petitioner.
Yes, Your Honor. And may it please the court.
Right.
Your Honor.
Ms. Hatch, can you address the issue of I don't even understand what the term esteeming it means. Will you clarify what that means in your opinion and what it means generally?
Your Honor, in my opinion, esteemed, as in the respondent esteemed that her page was a public forum, means that she created a public forum with her page. To my best ability, that is what I would say that esteemed means in this case. Also, Your Honors, student attendance is mandatory at discipline hearings. Requiring students to guess, as Justice Sandals stated, when to attend a meeting is an unjust burden to place on young children who are not always able to self-regulate, especially in a school setting. Also, the second prong of the lemon test is not satisfied because the policy inhibits those who do not participate in meditations and advances those who do, which is unconstitutional. To the second issue, in reference to pages 19 and 23 of the record, the respondent showed that she opened her page as a government public forum when she conveyed information to others on the page about school board matters that were important to Ms. Chung. The respondent blocked Ms. Chung from viewing that information, which is unjust.
But Ms. Hatch, if I get on my Facebook, LinkedIn, or Twitter page and post what's happening in Justice Baldwin's chambers, does that make my page a public forum for Justice Baldwin? I mean, what prevents anyone in the public from posting what's happening in government? You may answer that question.
Thank you, Your Honor. The difference here is that, as Justice Baldwin stated, someone in an official capacity needs to always be conscious of how they are using social media. And while you posting about things that happen in local government would not necessarily create a public forum out of your social media, when the respondent opened a page for her official position and conveyed information related to that position through that page with the public, she created a public forum and proceeded to discriminate against Ms. Chung by blocking her from that forum. And for these reasons, we ask this court to remember that each individual is entitled to a valued place in her political community.
And before you leave, I took up all the time in the rebuttal. I don't know if Justice Baldwin or Justice Tiarina have questions, but I don't want to keep them from asking because I'm a time hog.
Thank you, Justice Samuel. You did a fine job. I'm satisfied.
Okay, great. Thank you, Ms. Hatch.
Thank you. We respectfully request that this court reverse the appellate court's decision and allow Ms. Chung to assert her freedom from religion and her place in the political discourse of her city. Thank you.
Thank you, counsel.
Thank you, everyone. I'm just going to send the judges into the judges' room for deliberations, and then we're all going to come back to this same room. So competitors, feel free to turn off your camera until we all come back in. Do you all see the button that says go to the judges room? Is it not sending you?
It is. I don't see it.
Let's see.
I'm just going to click join.
Okay, perfect. Alex, do you see that one? If you hover over where it says judges room, or so click breakout rooms and then.
Okay. Thank you.
Yeah, no problem.
All right, Chief Justice, did we just begin talking?
Yeah, we can just start talking. Why don't you start? Since you've got good audio right now, let's take advantage of it.
Right, and then it blinks out right as you said that. Let me say this is the same thing I said to the judges as we were sort of filling out our forms. In this type of competition, I love to see the sense of realness in the human being. So while some of you are cold as ice and you are so prepared and ready to go, what draws me to you is the realness of who you are and how you present your argument. That may be because I sit in a criminal court, and that is what's most probably most persuasive when you're in front of us, criminal judges. I don't know that I'm speaking from only my own personal experience, but that's what drew me into one of your arguments. Two of you particularly stood out for me, and it is when you're thrown by a question from the judge. It's obvious that you're thrown, but you rally and get it back together. And I saw two of you do that really well, because these were off questions that weren't even on the list of questions we had to ask. But you regrouped. I saw the look of, oh no, this is that question. But you smile and you answered the question, whether you did so substantively, not so much, but at least you tried, and you were all flawless in that type of situation. So I really appreciated that. And I don't know if we're supposed to give individual information, but as a whole, that's what I appreciated, and that's what I looked for.
And I think, Justice Baldwin, if you have Judge Baldwin, I'm gonna refer to your real title. If you, I think, do y'all mind individual, like, I guess we call them critiques, but I don't think you're gonna get a lot of critique. You'll get just a lot of, like, good jobs. Go ahead, Justice.
Okay, perfect. Well then, Ms. Harris, you were one of the first, I thought, that got thrown a really big question that took you off script. And I could see it in your face. And I only say that because I remember being in your shoes, and one of the judges said the one thing they appreciated is that I would smile, regroup, and re-engage. And so again, I scored highly when I saw things like that. You would think that's probably a flaw, but I think it just shows you as a human. And that's what I think is most persuasive when you are arguing on behalf of a client, is the ability to show that we are human and we have these human emotions. It is real. It makes you real. So that's what I liked about that. And of course, you had great argument skills, great knowledge of both the law and the facts in the situation. Ms. Hatch, at first I thought she is cold as ice, so smooth. And then finally, you get a question from Justice Tiarina, and she threw you off. And I said, finally, somebody got her. But again, you rallied. I saw you smile, take it in stride, and jump in there, and that was great. Oh no, am I frozen again? Did you hear the last part about it? You rallied, and of course you too, but you really were smooth in your argument, and I fully appreciated that. Ms. Ogan, you two showed that, probably not as much as everyone else, but I love that your smile was just who you were naturally. I appreciated that, seeing it come through your argument as well. I thought it was related to the fact that you anticipated what we were going to ask you, which is what a good advocate does. You anticipate the issues so that you can give us proper responses. That was great. Ms. Velasquez, good responses. Refer to the record. I thought that was excellent. The fact that you were sharp like that, referring to the record like you did, I thought that was great. Which meant that you were on top of it and you were knowledgeable about what you were saying. Good argument as well. Rebuttal, I found maybe even most persuasive. When you go back and refer to what a judge has said and use their argument against them and into your argument, flawless. That's all I got.
And so, I'll go next, if that's okay, Alex.
Of course.
So first and foremost, y'all were just all amazing. Very, very good. I had to ask when we first got into the breakout, whether or not this was the 3L competition or the 1L competition, because y'all were so poised and composed the entire time. And I remember it's been more than 20 years ago when I competed in Blakely Butler, and I was nowhere near as good. So kudos to y'all. The fact that this is your base starting point scares the crap out of me. But kudos to y'all. And, and then the second question I asked when we got in there was like, so what percentage of competitors were men? And, and Emma was kind enough to look up those numbers. And of course, I can't work my computer, so I've lost them already. But I think here they are. So she told us that 57.7% of all competitors were men this year, and that 54% of the judges, excluding the final, were men. So I don't know what that means, and I don't know if it's necessarily meaningful, except to the fact that, for a long time, my wife's a litigator, and I think for a long time it's seen as that may not be where women belong, but obviously it is, not only because y'all did such a fantastic job, but because, Justice Tiarina is a litigator, my wife's a litigator, and there's a whole swath of up and coming female professionals that are killing it. The game has changed and y'all are changing the game, right? And so kudos to y'all. So with that, Ms. Harris, you were fantastic. You were, y'all, it's hard to critique because y'all were all so good. You did get sort of shook by one question, but you did a great job. And to Judge Baldwin's point here is Zoom lends itself to humanity, right? Because we lack the physical closeness. I think everyone on Zoom is looking for a human component. And so smiling, flubbing up, is amazing because one, we give a certain level of grace here that we normally wouldn't in person. But also it shows folks that, we are not infallible, and it's okay to be fallible, right? And as long as you're able to come back and get back on your train of thought, you were great. Ms. Hatch, I made this comment in the breakout room as well. Up until you got flubbed up, you were cold as ice, and that's great. So if I clerked for the Court of Appeals and I watched a lot of arguments, and you would be amazing in person, right? Because that's the person you want in a real situation, is someone that's, dispassionate. But in Zoom, like I said, at least I, like Judge Baldwin, wants the human connection. But when you did get flubbed up, it was great to see that, right? And so I don't know if that's a critique or a pat on the back. I'm not quite sure what it is, but your style lends itself better to an in-person argument than a Zoom argument. But I don't know what you take from that, right? I don't know where you go with that statement, because likely we're not going to be in this forever, and you likely won't be in, especially when you go to the courts of appeals, you likely won't be doing it forever. You may at the trial courts, because it's just a lot easier and cheaper for us to hold stuff via Zoom. But good job. You did a really good job. And I know that, I ask a lot of questions. I do that in real life as well. And so you did a good job of handling it off the bat in the rebuttal, and then getting back to what you wanted to get into, and then handling the last question as well. So good job. Is it Miss Ogan, or how do I pronounce that?
Ogan.
You did great. You just have this natural smile, great presentation, great poise. And I'm trying to, there's a woman that just ran for the Texas Supreme Court out of Austin, and you are like a striking resemblance her. And so every single time I saw you, I can't remember her name, which is horrible, but I was like, oh my God, it's like Justice not Tierina. I want to say Tierina because you're here, but it starts with a T. But you did a very, very good job. You pivoted well. You were able to state the case names really, really well. And you were very thorough in sort of your signposting. And I really like that. I mean, I really like that, and as judges, we don't care about your signposting. That's more something you're taught than we actually care about. But it's giving the roadmap is very helpful in letting us know how the argument is oriented. And then Ms. Velasquez, you got beat up. You just got beat up, and you did a great job. You've got a great smile on Zoom. Smile more. And that's, I used to feel sexist when I said that because I don't know if y'all are probably too old to watch The Simpsons, but there was an episode where Marge would always tell Lisa to smile, regardless of how she felt, to smile. And I don't feel that way. I think, you should wear your emotions the way you feel that they're most appropriately fit you. But because of the expressiveness here, and because you've got an amazing smile, if you let it come out, if you let that come out, I think it was more for me because I felt like we were beating up on you, and I really wanted to see that you weren't feeling the pain. But you did an amazing job just, going back to the record. And at the end of the day, that's all you have, right? So if you can just rely on that record and push back or punch back with that record, I mean, we just have to deal with it. So kudos to you. And again, y'all just did, I can't tell you how much better you did than you think you did. So that's all I have.
Hi, everyone. I actually just graduated a year ago, so I did both moot court and mock trial. And I'm an assistant criminal district attorney for Galveston County now, and I've had 2 trials so far. And I'm just so excited for y'all because without moot or mock, I would have no idea what I was doing. Everything that the judges tell you throughout this round, and if y'all hopefully do go on to join the advocacy groups, it's from real practicing litigators and judges who know what they're talking about. And good speaking is good speaking. If you can stand up, even if you don't want to be a litigator, if you want to go transactional, you're still going to have to at some point stand up and speak to a room full of people. So once you get that ability and once you're able to communicate your ideas, I cannot praise the Blakely Advocacy Center enough for just how much they've helped me, and I'm excited to be here also. So knowing that I am only 1 year removed, I do have just a bunch of little nitpicky things that apply to everybody as you're going forward that I still try to use also. For Ms. Harris, I thought you had a great natural speaking ability. I chose you as my best speaker. I do caution you on your word choice. Sometimes you would have some negatives or would be too extreme language. Like kind of like the obvious words, those kinds of things. I think once we get to this level, you have to acknowledge that like part of good advocacy is acknowledging the weaknesses, because then we trust you more. You say that is a great point, but it doesn't apply here. So acknowledging, you don't ever want to say every single time or obvious or extreme language like that, but temper it back. I loved your transition, bringing it back to the point and the theme from whenever the first question I asked you. I felt your passion there. I loved that. I do recommend you have more record sites. I also recommend giving both the case name and the year, because sometimes we don't know if it was like a 1950 case or a recent case. And then some judges factor into it who the makeup of the court was at that time too, and they put weight behind that. It's always okay to ask for a moment. My filler used to be and I used to have to tell myself, I still do, to slow down. So you're allowed to ask the court for a second, and they recognize that you're putting thought behind that question, that you're internalizing it, taking a second, and then you can come back even harder. I liked your closing. I think it's always powerful at the very end to have a policy reason for why this matters. A good 2-minute fallback question that you have prepped, that pulls the judges in and explains to them why everything you just said matters. I thought you were great. I was very impressed. For Miss Hatch, I thought you had a great intro. I argue that, so just watch anytime you say I would argue, take out that language, take yourself out of it. You want to always be relying on case law or other sources that are reliable, because you want to remove yourself as the advocate. You're not relying on just what you think, but on what the precedent is, what the judges think. Let's see. I thought your rebuttal was the very strongest at the very end. I felt your passion. You were there. You came into it. I loved that. And then just conceding some points of not using that extreme language also. But yeah, you were fantastic. All of y'all were. Miss Ogan, for case names, I do recommend you say versus instead of V. It's easier when you're saying the case law. Sometimes you would say yes, Your Honor, and you were saying yes, I understand your question, but your answer was actually no. So just be careful not to get that confusing. You want to make sure you give them your answer right away with your points. And I also just suggest never saying believe or I think, because it's not you, it's the respondents. You would say Miss Rivera, like you're advocating for her. So you're using her position, not what you personally think. Again, you were fantastic also. Like, I just reiterate everything that everyone else said. All of y'all were so great. Lastly, Ms. Velasquez, I thought your second half of your argument was a lot stronger. I think whenever you were answering questions, we could see more who you were, and that I knew that you understood all of the case law and had read it and you got it. Your record cites were great. And I just loved your style, especially towards the end. So extremely proud of all of y'all. Make sure to put this on your resume and keep competing and go out for Moot Court. If you don't make it the first year, just try to keep doing other competitions if y'all want, because y'all were all so great. So good luck with everything, and let us know if you ever need anything too. So.
And I'm interested from y'all's point of view, how this was, right? Y'all Zoomed for, I think, multiple rounds. I think this was your 6th round. Is that correct? How was it for y'all?
I thought it was a great experience. Even though it was over Zoom, I thought it was wonderful, very fulfilling, got a lot out of it. So yeah.
Exhausting?
A little bit.
Okay, that's what I'm looking for. Like, who's gonna say, like, this was exhausting? I can't imagine. And I again, this was over 20 years, me and Ravi, right? Over 20 years ago, my experience. And I remember the late nights, and but I also remember the relief of being able to do it live, and it was right there, and I was organized and look, and I looked like everyone else, right, in that process. This is different. How you stay focused, and you're really, I assume, in your own individual homes or wherever. That's a difficult way of doing it. So I applaud you all for the level of focus that you gave to this under those circumstances. It's remarkable.
Yeah, it's fascinating to me, right? I chose to come to the courthouse to do this because I've got other stuff going on today. But to me, in the real world, getting from point A to B can be stressful. Getting from my house to the courthouse or to Rusk or to the law school, right? So I think, being in the convenience of your own home, there's some comfort to that and that's prefaced with, if you have the ability to be in a private space that's quiet, because we are all not built equally, right? And we all don't have the same resources. And I think as judges, for sure, we've come to realize that over the last year, that Zoom is not. It is much more democratizing, but it doesn't complete the democratization process, right? There are still people without, and we all come to this with our own past. So did y'all find that better? Just not having to worry about, like, I only have to dress the top half of my body. I just have to go from my bedroom to my kitchen, my full. Was that nice as well? Or would you rather have been in person and deal with all the rigmarole that goes with that?
I'll go ahead and piggyback off of Ms. Hatch. I think that we absolutely had some barriers to overcome. Being in the comfort of your home is fantastic in some ways. Molly and I actually had the opportunity to be in the same room. We decided
looking at each other. Yeah.
We put our rebuttal together and passed notes just because, I mean, honestly, we were not anticipating being here today. We honestly jumped in. This is our first competition. And so being a 1L, it was nice to have some of that freedom at the same time and that comfort of being in your home. At the same time, in the middle of one of our rounds, I have housemates. They're walking in the house. They're doing dishes. I'm literally looking at my sink right now and I'm in the middle of speaking. So, there's some of that difficulty, but I do miss the courtroom. I would love to be there soon, but it has been a nice alternative for the time being.
Can I just throw something in based on what you said, though? So for Ms. Hatch and Ms. Harris, always expect to be in the final round when you start. Don't get in it if you don't expect to win. Now you may fall wherever you fall, and that's just life. And that goes really to all four of you. You are in the top for a reason. So always expect to win. Get in it to win. It really changes the trajectory of what happens. So that means no matter what you do, if you're going out for a job interview or whatever, or you're representing someone in court, always expect to, I realize I may have been frozen for a moment, always expect to win. Because what else are you there for if you don't, so it changes the trajectory of what you're doing.
Yeah.
Okay?
And as a corollary, there's just too much work in it not to want to win, right? The issue is, I mean, y'all put in a decent amount of work. I think y'all have to do briefing too, right? You have to do a brief. I mean, that's insane. So, I mean, if you're not going to put in the work to win, then don't, I mean, there are better things to do with your time. There are. I mean, life is, as you become a professional, and I tell all my students who intern for me and all that, I go, listen, you're in school to be a professional. You need to start making professional decisions, and people pay for your time. They literally pay for blocks of your time. And if you don't value your time, there's no reason they should. So only put your time into what matters to you.
And remember, every wall within a closed-in space has energy. Yeah. But if you put in negative energy, that's what you get out of it. So remember, positive energy, moving forward, stay focused,
meditate.
Just don't block anybody on LinkedIn. Yeah. All right, I think I'm done.
Y'all have any questions for us too? Moot or just regular questions, regular life questions, professional questions?
They're like, get to the end result. Right? That's what they want to know.
Sunday fun day. We're just standing in the way, guys.
I have a quick question. As far as Moot goes, how long do you normally get to prepare a problem?
It depends on each competition. Some of on how long you get and how long they give you. So it would just depending on, and I'm not sure how they're doing it now, but all of it usually is different for how long the competition lets you prep for. Some of them are 2 weeks, some of them are 4 months. Some of them you have multiple briefs you have to send in at a time. So, and people can factor that into like which one you choose to, because the competitions are normally each year, they're different. It's always like the third week of whatever, so they don't interact. So each of them depends on which competition it is.
Yeah, I think for the 2 out-of-state competitions I did, I think we got 3 months between when we got the problem and when we gave oral arguments.
Thank you.
Does anyone else have any other questions for the judges? If not, I'll go ahead and tell you the results. No? Okay. So thank you to Judge Sandel, Judge Baldwin, Ms. Alex Tiarina for judging the final round. Thank you to all of the competitors for passionately advocating on behalf of Gabby Rivera and Cecilia Chung. This has been a fantastic competition. I know I speak for the entire Moot Court team when I say that we strongly hope that all of you will try out for the team. So without further ado, I'm thrilled to announce that the champions of the 2021 John Black Moot Court competition are Alexandria Harris and Molly Hatch. Congratulations, y'all. And then I will now announce the Best Speaker Award. So we asked the judges in every single round, including the preliminary rounds, quarterfinals, this round, to just vote for one Best Speaker of the 4 speakers in that round. So I am thrilled to announce the Best Speaker of the John Black Moot Court competition is Chelsea Ogan. So congratulations, everyone. We are gonna get a group photo, and then I'm gonna get a photo with the judges and the winners, and then a group photo with the judges and Chelsea. So let me figure out how to, let's see. Okay.
Make Christine do it, Judge Weems. I mean, she's not doing anything.
Okay, let's see.
Are you talking about me? I'm here.
Well, you're here. I mean, everything I'd say behind your back, I'd say to your face, Judge Weems.
Okay, so everyone look at the camera and smile. Okay, let me double check that it was good.
I do a really bad job because I've got like a 55-inch TV in here, so I'm always staring at the TV, which isn't the same place as my camera, so it's...
Okay, let me do one more. Let's see. Okay, here we go. Okay, and then I'm going to try to move people's windows. Let's see. Okay. This is very complicated. Okay, I'm moving the judges here, and this is all being live streamed, which is fun. Okay, so here we go. Okay, so this picture is with Molly, Alexandria, and the judges. And I guess I'm kind of in it because there's like 3 rows. Let me see if I can move myself out of it. Hold on one sec. Okay. Okay, 1, 2, 3. Okay, and then I'm going to move Chelsea's window. Let's see. Okay, sorry, I'm struggling to... Okay, let me have everyone except Chelsea and the judges just turn off your video real quick. Okay, 1, 2, 3. Perfect. Okay, and that actually worked better. So I'm actually gonna have Alexandria and Molly come back on, and then Chelsea and I will hide our videos and we'll retake that one. Perfect. Okay, 1, 2, 3. Okay, awesome. Well, thank you so much. And thanks to everyone who's helped out, who's watching. I was kind of refreshing to see how many viewers we had. And I think I saw as many as 23 at one point. So yeah.